get that little microphone symbol?
Yeah, it's on.
Okay.
We're on.
Good morning, Mr. Meek.
Good morning.
Opposing counsel is here. Do you need a breakout room with them, or are you ready for the judge?
I would leave it up to him.
Mr. Callahan?
Yeah, I have no issue. Speak with opposing counsel. I don't know what there's much to talk about. I don't have authority to settle at all, so I don't really see a point.
Okay, all right, I'll let the judge know. Thank you.
Thanks. Yep.
Thank you.
This is 2301467 LT. This is Cooper Equity versus Heather Dawn. May I have your appearances, please?
Kevin
David.
Callahan. Kevin Callahan for plaintiff, Judge P78273.
May it please the court, Jeffrey D. Meek, appearing on behalf of and with the defendant, Heather Doan.
Thank you. Today is the day and time set for hearing on the plaintiff's motion. Mr. Callahan.
Yes, Judge. At this point, we filed a motion under 4.201J2, which essentially says is there is no triable issue of fact here. My clients purchased this property from the owner, and they are the title holder. They submitted a 30-day notice to the occupants of the property. The occupants of the property did not vacate, and we initiated this action. There are no defenses. There's no triable issue here, and we should move forward to judgment.
Anything else, Mr. Callahan?
Nothing further, Judge.
Thank you. Mr. Meek.
Yes, we've briefed the issues and cited the pertinent case law. I did not get a reply brief or any kind of response. And we also filed the affidavits of Heather Doan and Dwayne Britton, and they've both been in possession for 18 years. They were buying the home under a deal with Heather's stepfather, and the case law is crystal clear. It's just so basic in real estate law. The person in possession, that's the notice to the world that there's an interest, some sort of an interest that the person in possession has in the property, and any potential buyer, it triggers a duty to them to investigate, undertake an investigation and do their due diligence, find out what the extent of that interest is. We never discussed anything, my client, nor Mr. Britton, who by the way, wasn't named as a party on this eviction case, but he's in possession. You've got his affidavit there, and they just didn't do their due diligence. They purchased the place on the cheap, approximately $100,000 less than the value, which raises suspicions. We don't know what the buyer was told, what the seller said, or anything. We need some discovery to find out what was said. The leading case I've cited from Michigan, Hull versus Gaffel Oil Company, Justice Butzel opinion. And he makes it clear that someone in possession can have an unrecorded interest in the property, and the buyer is obligated to investigate and find out what the extent of that interest is. That was never done here, never done. And then they adopted this opinion of Dengler versus Fowler, where it was an unrecorded option to purchase that was oral, was not recorded, not in writing. And the Supreme Court of Nebraska honored that deal vis-a-vis the buyer, and Justice Butzel adopted the ruling in that case, the holding in Dengler versus Fowler. And so there is definitely a triable issue. And the other thing is, why did they buy it so cheap? Were they told, well, you're going to have to undertake a battle with Heather? She's supposed to buy it. We don't know why the price is so cheap. Why it was a fire sale price. Then they admitted that they bought the place sight unseen. They admitted they didn't do their due diligence. It's very, very clear. So I think we do need a jury trial to have a jury decide whether they met their requirements of due diligence, whether my client and Mr. Britton were the buyers after 18 years of payments, after putting a new roof on, a new furnace, a new water heater, remodeling the kitchen, maintaining the place, then raising an issue because about 2 years ago, the neighbor was installing a fence, and Heather was concerned that he was encroaching. she spoke to her stepfather about it, and he said, well, you take care of it, you're buying the house. So we definitely have an interest in this property. Also, I did devote part of my brief to the fact that partial performance takes an oral agreement out of the statute of frauds. Now, none of these issues, not a single one of them has been refuted or briefed by the other side. And so I think it's pretty clear that the law I've cited should be applied to these facts. We should have a jury trial and we should have some discovery. This is not, some minor situation. It's a situation where the house that the assessor says is worth $166,000, and the Zillow's estimate comes in at 100. I think it was 186 or 188,000. I attached it to the brief, and this buyer not doing their due diligence. Why should they get a big windfall at the expense of this family who's been paying on this house for 18 years? It just cries out for a trial, a jury trial. And Your Honor, I believe I have treated everything in the brief. The other thing is, like I did mention, that Mr. Britton was not named, and he's in possession too. That shows you what a poor job they did under due diligence. It really does. Thank you, Your Honor.
And if I can respond to that, Judge.
Was that it, Mr. Meek?
Yes, Your Honor. Thank you.
Thank you. Mr. Callahan.
My brother counsel here makes a lot of issue about due diligence and what we need to do for due diligence. My clients are real estate investors. They buy property at the cheapest point that they can buy it and then turn around and sell it to somebody for a profit. That's their business. So if they were approached with an offer to buy a property for cheap so they can make a profit of it, they're going to do it. There's nothing illegal. There's nothing wrong with that. And the facts of this case are the purchase price, which is the $76,000, was what was remaining on the mortgage that was held by Benjamin Young, the previous owner of the property. So essentially, the transaction here is that the property was to be purchased for whatever's on the mortgage, and then my client would turn around and sell it for a profit. There's nothing wrong with that. I'm curious in this is that even if we accept Attorney Meek's assertions as true or as legal at this point as it stands, what would change? So my client then, as a purchaser of a property, would have to honor this oral agreement that may or may not be true to accept these mortgage payments until the end of time. Like it really doesn't make any sense. And further, Your Honor, the cases that are cited are from 1919 in the 1920s. This was well before the Summary Proceedings Act, which was adopted in 1961 in Michigan, that allows for people to get property back once they purchase it or if they rent it out. There was no lease agreement here. There was nothing in writing here about this scheme to pay the mortgage off eventually over time. And the other side here just grasping at straws on just trying to keep this person in the house that this Heather Doan has no legal interest in at all. My client is the deed holder, and the longer this drags on, the more it's costing my client.
Your Honor, if I may reply.
Absolutely.
Yes, my client is in compliance with Your Honor's order on the escrow order. She did come and pay the money into the court. I've got the receipt right here. And if what we're saying is true and the jury finds in our favor, then yes, they would have to honor that agreement. And it's very easy to figure out how long the payments would go. There's these things called amortization schedules, and I'm sure Your Honor is well aware of them. And we would just figure out the amortization schedule, and she would continue to make the payments in accordance with her agreement, because they would have bought the property subject to her interest. And now opposing counsel, he says there's no question. He's raised all these questions of fact. He said spewed out all these things, but he doesn't have a single affidavit to rely on. And counsel's recitation of the facts that's not enough in a court proceeding. is very clear. Without an affidavit or anything, he can't rely on any of these facts that he spewed out. And, you know, the deed that he's presented isn't even really in recordable form because the notary, you can't even tell who the notary is on it. And it doesn't show it was even recorded. That raises another suspicion, a red flag. Why wasn't it recorded? You know, why don't we have any affidavits? I think it's crystal clear that the family I represent, that they're entitled to the benefit of their bargain, and they performed for 18 years, which took it out of the statute of frauds, Your Honor. Thank you.
It's just absurd that the argument here that a court should force a contract then on my client that purchased a property, but we're going to force you to have this person in your house and paying the mortgage payments on a mortgage you don't have. It makes little sense, Your Honor. And as you know, a deed does not have to be recorded to be valid. This deed is valid. I rely on the deed. There's no other issues here. My client is the title holder, and there's nothing else at issue.
Anything else, Mr. Meek?
No, just once again, that the cheap purchase price really raises red flags that they knew that they were going to have problems on the title when they bought it. You know, we really feel we have the opportunity to take depositions and find out exactly what was said. You know, what due diligence did they do?
Absolute speculation. So, but I rely on the deed.
Mr. Callahan, Mr. Meek, were you saying something else, sir?
Yes, I was just going to say, he says it's speculation. Well, he can't just say that without affidavits or anything like that. And that's why we need to take some depositions, have some discovery. This is a big deal to my family, the client that I'm representing. It may not be anything to these, high flying real estate speculators, but it is to this family.
Anything else, Mr. Meek?
No, Your Honor.
Anything else, Mr. Callahan?
Nothing further, Judge.
Thank you. The court has had the opportunity to review both the motion and its attachments and the defense response brief and attachments. And I guess what wasn't said this morning was that this is a simple termination of tenancy case. The plaintiff has shown itself to be the owner of the property. It served notice, 30-day notice upon the defendant. That notice, I believe, was dated July 20th with a move-out date of August 22nd, 2023. The defendant did not vacate the property. The court has listened and has not heard a triable issue of fact regarding this termination of tenancy. Will grant the plaintiff's motion, finding that there is not a triable issue of fact. Plaintiff is entitled to judgment as requested. The only issue and concern that I have, Mr. Callahan, in entering an actual judgment is a move-out date. If, excuse me, as Mr. Meek indicates and as is contained in the affidavits of both Mr. Britton and Ms. Doan, they've lived there for 18 years with 2 children. The statutory 10 days does not seem sufficient time to allow them to gather their belongings, pack up, find a new place, considering we're reaching the holiday season. I don't know how old the minor children are in terms of them being in school, which is not typically a concern of mine, but given the fact that they've been there for as long as they have, I would ask your client to be generous in the amount of time allowed for them to vacate the property.
Unfortunately, I don't have any authority to extend the time, although I do understand the circumstances. And I would leave that to the court's discretion to add additional time, especially in light of the escrow payment being released to my client. That helps a little bit. So I would not object to a 30-day move out if the court would order that.
That was exactly my thought. Mr. Meek?
Well, with the holidays, 30 days, gets us right in the middle of the Christmas season. So I would ask for 60 days, provided that she's current on the escrow order.
So you're talking about January 7th, we're not going to move out on the odd day of the month.
But even if we have an order, say, 30 days from today is the 17th or so of December. If we try to apply for a writ and it bumps up against the Christmas, it's not gonna be, it either is not gonna be signed or is not gonna be executed during the Christmas holiday anyway, so, I don't think there's any issue there.
Mr. Meek, respectfully, what the court, excuse me, will do is enter a judgment that indicates that the occupants, tenants, Ms. Doan, will vacate the property within 30 days. 30 days actually falls on the 17th of Sunday, December 18th, 2023, that the escrow that is currently held will be released to the plaintiff.
Thank you, Your Honor. Do you want an order to release the escrow, or will the court supply that order?
If you would submit, have your office submit the order to release the escrow, it'd be
Okay, I'll
most
submit the-
appreciated.
Absolutely. I'll submit the order and the judgment.
Mr. Meek, anything else?
You're saying that they have to vacate December 18th?
Yes, sir.
Okay, I'm not sure what the escrow period covered. That was a month. So that would, so anyway, the 18th though, I mean, that's right before Christmas. It's not easy to find a place right now. And like I said, Mr. Britton wasn't named, so it wouldn't really cover him.
Mr. Meek, I understand and I respect that, but when you look at the fact that there was a notice to quit from July 20th, 2023, this was coming. So this is not a surprise. The question is how being prepared, and I think 30 days is generous given the state of affairs here. If Mr. Callahan, if you and Mr. Callahan have additional conversation, there's some additional time that you work out between yourselves and you submit an amended order to the court, that's something between the two of you. From this court's perspective, 30 days is generous. Mr. Callahan is correct, the 18th, and then you look at the holiday and the court being closed, and even with the submission of a request for a writ, will it be signed before the end of that week, the next week? Those are all guesses and hypotheticals that the court won't entertain at this point. And I hear your concern. There has to be some conclusion to this matter, and that the court has placed its conclusion of the findings on the record. Anything else, Mr. Callahan?
Nothing further, Judge.
Anything else, Mr. Meek?
No, not at this time.
Thank you.
Thank you.
You both have a wonderful day.
You too.
Thank you.